to the public. Can I welcome members to the 60th meeting of the Committee for Justice? Can I offer thanks and appreciation on behalf of the Committee to the Bar of Northern Ireland for hosting today's meeting, in particular to Sinead and her team for coordinating all of the logistical arrangements alongside the committee team. So thank you very much. Can I advise members that the committee meeting will be audio recorded, but given that this week is an external meeting, the proceedings are not being broadcast live. Can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are in airplane mode and all devices are muted. Attendees can also connect to the Wi-Fi and password details are available alongside the gallery rules on your seats. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that both oral evidence sessions with the Lady Chief Justice on taxation and delays in the justice system will be recorded by Hansard, and can I seek your agreement to this? Agreed?
Agreed.
Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration. Any members who have interests to declare in relation to today's business should do so now or when the particular matter arises. Are there any declarations?
Member of the All-Party Group on Access to Justice, which are the Secretariat.
Yep.
Likewise.
Okay. Any others? We'll maybe just do a catch-all for everyone who's attended the All-Party Group Access to Justice, although there are office holders here too. So, Brian?
Yep. Just under matters arising, there's a letter from the Committee for Finance, just to declare I'm a member of that committee.
Okay, thank you. Apologies, agenda item number 1. I have an apology for Morris Bradley, and I think that's it, with a clean sweep otherwise. Can I welcome Aoife to her first meeting as a new member of the Committee for Justice? Aoife has now replaced Danny Becker as a member of this committee. So Aoife, you're very welcome to what is a very good team. Yep. Probably the best team selected for the whole history of the Northern Ireland. So you're very welcome to be part of this team. Can I seek members' agreement to write to Danny Becker to express the committee's thanks and appreciation for his contribution and dedication to the work of the committee over the past year, particularly in scrutinising the Justice Bill? Members agreed?
Mm-hmm. Agreed, yeah.
Agenda item number 2 then, draft minutes. Can I inform members that the draft minutes of the meeting held on Thursday the 15th of January 2026 are pages 5 to 20 of the meeting pack? Can I ask members if they are content that the minutes are a true reflection of the proceedings of the meeting held on the 15th of January 2026? Members agreed?
Agreed.
Agreed, yeah.
I just need to make sure my device is on silent here in case it beeps. Agenda item number 3 is matters arising. 3.1 Committee for Finance, scrutiny of the draft multi-year budget for 2026 to 29/30. Can I refer members to pages 22 to 23 of the meeting pack for the relevant papers? Can I inform members that the Clerk of the Committee for Finance has written to all statutory committees seeking their views on their respective departments' 26 to 29/30 budget allocations, with returns requested by Friday the 27th of February. The Finance Committee has also advised that it would welcome comments on the Department's 25-26 budget position and management. The Finance Committee has advised of its intention to bring forward a motion for debate on that draft 26 to 29/30 budget prior to the Easter recess. So can I remind members that at last week's meeting on the 15th of January, the Committee agreed to ask the Justice Minister for her views on the Finance Minister's draft budget proposals, to schedule an oral evidence with Department of Justice officials on the draft budget proposals, and to seek the views of the Department's 8 non-departmental public bodies on their indicative draft budget allocations. The Clerk is liaising with departmental officials to determine the most suitable date for the oral evidence session, with the aim of scheduling it by the 19th of February at the latest. This will allow a committee response to be prepared for consideration on the 26th of February prior to issue to the Finance Committee. Can I ask members if they are content with that approach? Content?
Content.
Yeah.
Okay. Can I ask members if there are any other matters arising from the minutes that they wish to raise at this point? No? Okay. So agenda item number 4 then is Justice Bill Taxation, the Lady Chief Justice oral evidence session. Can I refer members to pages 25 to 76 of the meeting pack for the relevant papers? Can I inform members that today the committee is receiving oral evidence from the Lord Chief Justice, the Right Honourable Dame Siobhan Keegan, on broader matters related to taxation, and we also have the taxing master, Master Joe Moore, here also with us today. Can I remind members that it is not the function of the Judiciary to comment on policy matters. The purpose of today's session is to gain an understanding of the taxation process, which will help members when considering the potential impact of the taxation proposals at clause 28 in the Justice Bill, and then of course any further amendments that the Minister proposes. Members are therefore kindly asked to factor this into their thinking when asking questions to the Lord Chief. Can I welcome the Right Honourable Dame Siobhan Keegan, the Lady Chief Justice, to the meeting. You're very welcome. Thank you very much for being here today, and then also to Master Moore. Thank you for coming also for this evidence session and for hosting us here in this building, and for allowing us to come out of Stormont to be here in what is your world. So it's very, very good to be here. So without further ado, can I ask then the Lord Chief if you want to open up with an opening statement on the taxation system?
Yes. Well, firstly, Chair, thank you very much for the welcome. I'm really delighted that you're here. I understand the Justice Committee came to this building in 2015, and it is really a brilliant thing to see the committee out and in the Royal Courts of Justice. I know some of you because I came and gave evidence in 2004, and there are also some new members of the committee, and I'm really happy to assist you as best I can on these two issues. I did bring along Master Moore, so he is here as well. He is the taxing master. I think, as you've already said, Chair, I can't comment on policy or anything that's politically controversial, but I hope I can help a little, and I'm certainly willing to take questions on this issue of taxation, perhaps to deal with what I think is a bit of a mistake about it, what it means, how it's been a part of the justice system, where the authority to have a taxing master comes from, and then the place that we're in at the minute, because I know that some proposals are in the Justice Bill, as you say, clause 28, to look at taxation. So I did send a letter, which I hope the committee members might have, about this. It's a little bit complicated, I understand, with the recitation of bits of law, statutes that deal with taxation. So let me try and summarise it in a comprehensible way, just to confirm. That's my letter of 24th of April of last year. So, context, I understand, for the discussion in relation to taxation is the Department of Justice proposing a number of changes to current procedures that have been in place for a long time in our jurisdiction. The taxing master, to start with, is a judicial appointment. That appointment is carried out under the auspices of the Northern Ireland Judicial Appointments Commission. It uses criteria tailored for the role, And the role is someone who can deal with costs, to put it at its most basic. And as you may have seen, the most recent appointment of Master Moore was in September 2024. The criteria for this type of role is that you've been a solicitor or barrister of 10 years standing, but you have an understanding of costs. And Master Moore was a solicitor in private practice who practised in the area which he's now dealing with. So he had to deal with costs as a solicitor. He tells me he also taught at the Institute in relation to this. And obviously he got the job, so he was qualified to take on the role. Why do we have a taxing master? It's a rather archaic title, I think, and that can cause a little bit of a quizzical look at what it is. Well, why do we have it? It's actually very important to frame this conversation with what our law says. So the main governing statute that governs how our courts operate here, our senior courts, is the Judiciary Act 1978. It provides at section 59 that the costs of all proceedings in the superior court, so the High Court and the Court of Appeal, shall be in the discretion of the court, which is the power to determine by whom and to what extent the costs are to be paid. And section 60 vests the jurisdiction in the taxing master. That discretion, however, in relation to costs, must be exercised in accordance with rules. And there's an order of the rules, Order 62, that sets out the parameters. So that deals with civil costs in particular. So that's the law. And we've had that law, as I've said, for a long period of time. The taxing master doesn't work alone because he's part of an infrastructure which is called the taxing office. And there's actually a very good information page on this online in relation to how the Court of Judicature Northern Ireland Taxing Office works. If you go on, you can actually see this. I did that today to have a look at what a member of the public or you could glean by way of information about the taxing office. So the taxing office itself is based here in the Royal Courts of Justice. There's an administration team and the master has the judicial role. The judicial role, as I've said, is about costs. What is it? Well, it's a role where the taxing master is responsible for assessing and certifying legal costs in a range of cases. He actually has an important role for the public because if a member of the public disputes a legal bill with their lawyers, the taxing master can step in to make sure that lawyers haven't wrongly charged somebody. But I think actually the focus for you is probably his role in looking at bills where the money is coming from legal aid, so that's public money. So that's a big part of the work, and I think, if I'm right, about 70% of the bills are in that area. So that's what I'll call the legal aid bills. And you can see I put in my letter all the different statutes. I don't think I need to go over that. You can take it that they cover a range. So we're in the civil world, we're in solicitor-client costs. He can deal with disputes on that. And then we're in this other world of what solicitors and barristers charge that comes out of legal aid that the master can look at. And I think that's really the issue here. That spans civil, so civil and also criminal. So that's because of the provision of legal aid across those divides. Volume can vary, but I think, as I said in my letter, normally we have audited this as about 1,000 to 1,100 cases each year. Total number varies. I don't think we see particular spikes in that, but it can vary a little. But as I've already said, 75% legal aid. A significant part of that work in relation to the legally aided work emanates actually from legal orders. So if somebody's legally aided in the court, they have to get what's called an order for taxation. Again, that can sound a bit archaic, but if you've got a legal aid certificate, you ask for an order for taxation, which starts this whole process. And obviously members of the public need legal aid. It's a strength that we have within civil and criminal law as well, that people can have the entitlement to the best lawyers through public funding, in my view. So they have legal aid. A court makes an order for legal aid taxation. But that's not the end of the matter, because there is a check. There is a check to make sure that the lawyers are asking that legal aid pay a proportionate and proper sum for the work they do. And I should say the other check that's quite important to mention is that, and this is self-evident, but it is important to articulate, the taxing master, as we all do, as I do, have a duty to the fund. This is public money. Taxing master is well aware of that. I'm well aware of that as a judge when I'm hearing cases. So that means that there is an independent judicial office holder looking at bills. Now, there are different stages in the system whereby bills are checked. I mean, some bills can come in and they're wrong because the legal aid certificate didn't cover the period claimed. That's easy. The administration staff send that back. Some bills might come in, they're unsupported by evidence. Evidence, I mean broadly, that the office are not satisfied that there's enough to vouch for the bill itself. I don't think that's particularly difficult either. They're sent back, so they're not processed. It's this area then that I think is attracting attention, whereby the master looks at the level of claim, which is another obligation that he has. So that's judicial scrutiny. I'm very clear on that. He has powers to direct if he wants further information, to hear from people if he wishes. And he can look at a variety of things. Let me highlight just a few of, I think, the salient issues that the master is looking for. Whether the rates claimed are applicable, so the hourly rates, and I'll come back to that in a minute because I know the department have raised a few issues about that. Whether the work claimed is actually covered, whether two counsel are covered. Sometimes there can be one counsel certificates and not two counsel certificates, or the authorisation for senior counsel comes in later, so he can check that. Whether the number of hours marked are proportionate and properly claimed in a case. Whether the costs claimed are reasonable in the overall context, and whether the complexity and seriousness of the case merits an uplift. So without going into too much of the detail on that, solicitors can claim uplifts for complex cases. There's provision for that in the rules, but they have to justify that. And the master can look at all of that. That's Order 62. So this is a very much an iterative process. The bills that come in, and I mean, a lot of these cases, I'm sure the master will agree with me, are at levels and in areas that are not particularly complicated, but there are other cases that are, and you would have to have a very close eye on the bigger cases, which he does. He can ask to see more papers, as I've said. He can ask to see people, solicitor and counsel if he wishes. And actually, at the sharp edge of this, and you know, I don't think I can shy away from this, if he thinks that there has been an inappropriate level of fees put, he can actually send the matter to the professional bodies here. So that's the Law Society or the Bar Council. That's the broad picture. It probably does a disservice to what Master Moore does with his staff. And I know Master Moore is new in the job, but as I've said, he comes from a place of experience in this area. But we also have really, as you can imagine, it applies across the board when you look at these types of complicated issues. He has really dedicated staff who know the territory as well, who do great work here in this building on this. Solicitors' hourly rate, I know, is mentioned in the department's thinking. It's the Master who sets that. He's authorised by law to set that. It did increase recently in April of last year. And what I would just like to point out in relation to that is that didn't just emerge from nowhere. There was a working group set up in relation to the solicitor's hourly rate, chaired by a High Court judge, Mr Justice McAlinden. He drew together a group of people, a working group. As you can understand, what you need in a working group is representation from all areas. So, as I understand it, I think there are about 20 odd on this group, to include not just bar and solicitors, but defence practitioners, plaintiff practitioners. It also included the Legal Services Commission, and it included the department. So the department were cited on this work and were part and parcel of the group. And it was evidence-based. There was evidence that came from an expert report on this from BDO. It was shared among everybody. And then the Master had to look at what the right increase was. And it's clear as day that there had to be an increase, because it was 11 years where there wasn't an increase. And I suppose the lesson in that is the danger of letting these things slip for long periods of time, rather than have inflationary increases on a staged basis. That's why I think this looks perhaps more acute than it really is, because it obviously had to go up. The experts supported that, and the Master settled on the figure. Same goes with the interlocutory fees. I think that's been mentioned by the department as well. Interlocutory fees, just to explain to you what that means, they're fees for things like the applications that come to court, the affidavits that you file, the responses that you file, the skeleton arguments in the current world where we use written advocacy a lot more are really important. So we had to look at those. They hadn't been looked at for 11 years. Again, they also go up. And I would suggest, as a matter just of common sense, that had to happen on an inflationary analysis. So that's the working group that made the recommendations, and they've now all been implemented. And what I would say as well about the transparency of this, this was all, as I've said, mapped across the various different people who'd be affected, but it was also published, and the Master put out what I think is a very informative note on the Judiciary NI website, saying where this all came from and what happened. So that's where we are. It's a very broad brush of what the Master does here, and it also, I hope, taps into the two issues that have changed the landscape a bit, because obviously the costs have gone up on these two platforms, so the hourly rate and the interlocutory fee. And I know the department in clause 28 had a different approach to start with on taxation, and have now revised that. As I've said, I'm not getting into policy, but I can totally understand whereby you might want to just tease out where that comes from, what it means, what the utility of it is. So if I can answer anything, or Master Moore, please, I'm happy to do so.
Thank you very much. Thank you, Lord Chief, for that presentation. I'm very aware, Master Moore, we're in this room talking about you. Yeah. You're sitting there very quiet. Can I offer you to speak if you wish, or are you happy enough just to go straight into questions?
Do you want to add anything to anything I've said?
I suppose just in terms of the role and there's maybe an air of mystery about the role of taxing master. So I am the equivalent of a cost judge, which would make a nice simple description of it. So there are maybe 100 cost judges in England and Wales who undertake the exact same role that I undertake. There's a legal cost adjudicator in the Republic of Ireland, pretty much, who used to be called a taxing master. So I'm the only one with that remaining title. But it's essentially a cost judge, and it's obviously an important function. Just to supplement what the Chief has said, before a case gets to me, there are a number of stages, particularly in relation to cases that are publicly funded. The very first stage is that the Legal Services Agency have looked at the case and authorised certain steps to be taken by solicitors, barristers, and also experts. It's not just lawyers involved in legal aid cases. Quite a bit of expenditure comes on. If you had family case, you might have psychologists, you may have expert witnesses. But any work been done by any participant as a representative has already been, at the start, been approved by the Legal Services Agency. So they will have granted a certificate which allows certain steps to be done by a solicitor and maybe a barrister or two barristers. That's the first stage. Second stage is that a judge will have looked at it and decided that an order needs to be made for taxation. And then the case comes to the taxing office. And it is a very robust process. The bills are really carefully checked by a team who go through the whole process. But the representatives have to itemise what work they do. They have to put in a report in case. I'm interested in what work have you done and how you should be reasonably paid for it. So when it comes to me to assess it, that's essentially what I'm doing in layperson's terms. Has the work been done reasonably, and what are the reasonable costs with that? And I'm very mindful in a publicly funded case that I am there to protect the legal aid fund and to ask robust questions of everyone who's looking to be paid. I do come to the role, whilst I'm in the role 18 months now. I was a solicitor for 30 years, and I ran a big law firm as managing partner, and costs were pretty much the fundamental part of that role. So I've come to this knowing exactly how these cases should be costed, what's a reasonable cost and what's not. And in 18 months into the case, I've looked at probably 1,500 cases across the full spectrum of work that is legally aided. So that's where I am at present. I'm certainly happy to take any questions that you have about the role. I don't think it would be appropriate to speak about any individual cases.
Yeah.
And I certainly don't think it's appropriate to talk about taxation reform. So if there is any specific question that any of the committee have, I'm more than happy to assist you where I can.
Okay, thank you very much for that. And we will try and chart a course avoiding policy where we can. It's just our world is all policy, and so it might be hard. But you'll obviously you reserve the right to tell us to back off or to stop or not to ask that question. I suppose if I could, Lord Chief, go back to the very start. You talked about law and the basis of law, and you talked about the 78 order. Can you tell us if you know what actually went before 78? Has taxation always been a thing?
I actually don't know the answer to that off the top of my head. You're going back a long way. And
yes.
I'm born in the 70s. I'm having a difficulty, but I imagine you're looking at some sort of other process. But Judicature Act really settled the current landscape, so I won't guess.
Right. Okay. No problem. It's just a quirky thing that I have in my head about law and the interest and the intrigue of that. It's very, very clear there's an independence with the taxing master, but there's also this other rub then about public money and the department. But with the office of the taxing master, what do these clauses mean for the practicalities around manpower, workforce? Maybe is a better word now. And would that mean, in a practical sense, that would have to transfer from your office to the department? And then how would the department cope if there wasn't a transfer of workforce?
In taxation reform?
In actually assessing the bills.
Yeah. Well, somebody has to assess the bills. I don't perceive that the department are now suggesting that the taxing master is redundant in doing that work. Actually, could be wrong about that, but I think what the latest proposal is really it boils down to the department wanting to set the rate, but you will still have to have somebody oversighting. I would suggest, from an independent perspective, the actual content of the claims on this basis that we've explained the taxi master currently operates.
It's just, and maybe I'm wrong, but
Yeah.
I thought that clause 28 basically took that function into the department to actually assess the bills,
Yeah.
the itemised bills. And then the new clause that the Minister's talking about by way of amendment was actually then a barrier to set the rate,
Yeah.
of which was changed this year.
I think you're right on clause 28 as it originally stood, which means that you're passing the work to a different organisation, but the work still has to be done.
Yeah.
That is an issue that I think the profession certainly would have a perspective on in terms of who assesses the bills. So that move from independent office holder into the department. So that was the primary issue. But then I think the amendment or the secondary aspect was the hourly rate. But you still have to do the work. I mean, you're not saving money with that, I would suggest, in terms of the audit that you need to undertake that I've spoken about with any bills.
Yeah. And and again, this is a question for the department, I know, but it's just knowing whether and how they obtain the expertise of an office that has been working and operating since 1978, and how then they transfer that expertise, if that's exactly what it's doing.
Yeah, well, I mean, I think that's for them.
Yeah, of course. Yeah. I'm going to put it out then to Brian, first of all.
Okay. Thank you, Lady Chief Justice and Taxing Master. Appreciate your attendance today, and it's a pleasure to attend the Royal Courts here for the first time myself, and even noticing downstairs the similarity in the architecture department buildings, and where the courts were once planned to be located. But it's a pleasure to attend today, and thank you for your assistance to us. In terms of the bill before us, reading the wording of the bill, which is an amendment to the 78 Act, and trying to understand that, I find better assistance in some of the notes we've been provided. So is my understanding of it is that the department is seeking to take on the role of setting the rate itself for solicitors and, if possible, for barristers also. But the taxing master will still have the role of assessing the claims and determining that they are appropriate and in keeping with all the guidelines. So my reading of it is just that issue of the rate which it will be paid. So I think you've already confirmed that's your... I think
it started out on a different focus, which was caused the Chair's question, but I think it has drilled down into what you've said. I think,
There is another point where it says about precluding the High Court or the Court of Appeal of making a judgment on taxation. So I'm not sure what that means. Are there situations in which a barrister or solicitor asks for your judgment or your ruling, whatever the correct term is, challenges that? I'm just trying to understand that bit about that the High Court and the Court of Appeal wouldn't have a role.
I think that's actually something different. I think that's about the judges who hear cases not giving an order for taxation. I think.
Right.
Now, that is a difficult area. If somebody is legally aided, that they wouldn't get an order for taxation. There is some discretion within the courts on that, but by and large, as you can understand, if you have the benefit of a legal aid certificate, save exceptional circumstances. In criminal cases in the Court of Appeal, if you don't have leave, the court may not actually grant legal aid on a renewed application for leave. That's where I come across it. In other cases, having looked at this a number of years ago, I think if you're legally aided, you do get a taxation order. So I'm not sure I'm not sure how that would operate in practice if that element of judicial oversight is removed, let's say. But again, I'm in a policy world there that I don't really want to tread too much more into, because I'm not sure what the alternative is on behalf of the department.
No, given what you said earlier about if the order of taxation gives the entitlement to legal aid, I realise actually from what you're saying now that's what that's referred to.
I think it is, yeah.
So who, just clarify, who issues the order for taxation then? Is it the department? That's a court order.
That's a court order. That's a court order.
So, right, it is. So it's a court order, but not the High Court or the Court of Appeal?
No, it is a court order of the High Court or the Court of Appeal. If you're legally aided, you will have an order for taxation, which means that you can then submit your costs to the Legal Services Commission, and then ultimately they'll get to the taxing office.
Okay. I'll seek more clarification on. Maybe there's certain criteria here that I'll read more into this.
Yeah.
But it is the court anyway that makes that.
Yeah.
Can I just assist you there with that? I can only ever assess costs if another court has made the order at the conclusion of the case or at some stage of the case. The judge has said, yes, I've listened to this point and I give an order for the costs. I can only do that assessment. If a judge doesn't give that order, I have no jurisdiction to assess the costs.
Right. And is it primarily means-based?
No, that the judge won't have any role in that. But I said there were sort of 3 stages before it gets to me. The determination of whether somebody, in the majority of cases, has an entitlement to be legally aided is decided by the Legal Services Agency at the start, except in relation to some criminal appeal cases.
Okay. One last question, Chair. Just to clarify, we talked about the increase in April last year. Was that the 52%?
53, I think it is.
Right.
Maybe it says 52.
Yeah. That was the first in 11 years.
That's right.
Okay, thank you.
Thank you, Brian. Emma?
Thank you, Chair. Thanks to you both well, we've came to you. I just wanted to ask what engagement you've had with the department around this, and what, I suppose, do you feel there's scope for mediation, or has that been discussed, or could that be a way of...
Yeah, well, I have a very good relationship with the department in that they come and are transparent about what they are proposing. And in this circumstance, I thought the best thing to do was to ask the department to engage directly with the Master. So I know they did, and the Master can tell you what shape that took.
So in relation to the legislative proposal, well, I'll maybe go back a step. So the department were involved in the working group that fed into the hourly rate being changed and the practice direction being issued on interlocutory fees. So they were in attendance. I had a number of meetings with them as to, probably just introductory because I was new in post. But in relation to the most recent proposal as to how the legislation might change, which, as I understand it, is now a move away from removing taxation to setting legal aid rates for work in the High Court. That I had a meeting with the department at their request at the beginning of November, and that's when the department indicated to me this is it seemed to be as if we've decided we're going to do this instead of taxation. That's my impression.
So just if I can interject there, so that's really important. So they're basically going to amend what's in the blue pages of the Justice Bill, which is 28. So they're actually going to not add an additional amendment with 28. They're going to amend 28. Is that your understanding?
Well, again, I'm obviously have to be careful about discussing policy and how decisions that need to be taken by the Assembly. I have no real comment to make on that. But in terms of them giving me the information as to what they're intending to do, I'd understood that they were proposing to put to the Assembly a change which would introduce hourly rates determined by the Department for cases that are funded by legal aid. Obviously, I deal with a lot of other cases that have no legal aid involvement. The exact same process applies in those non-legal aided cases in terms of how I assess the costs.
So just so you're aware of my understanding there, or my understanding or misunderstanding, is that when I spoke to the Minister on this, I have never been in the impression that she is going to change 28, but she's going to add a new amendment to take the varies of setting the rate, the hourly rate. Also,
I'm not sure we can really say much more, except we've been open to the conversation. The Department have been open with us. What that translates into by way of amendment or otherwise of Clause 28 is, we can't really say.
Sure.
And we are open to any further discussion on it with the Department. We always have been.
Yeah, we haven't had sight of that.
No, we still wait on. We still wait
right.
on them.
To be honest, what I would say about this is it hasn't happened. I think the Department were here before you in November. This is quite a fast-moving area, so it may be that it's premature to give any firm steer about where the Department are or not, because this is all just over the last number of months evolving, I would suggest. But in answer to your question, I think the answer to it is there will be ongoing dialogue. We can, I think, assist from a point of expertise because we have the taxing officer and the taxing master. Bear in mind, we are not, able to obviously advance the competing arguments. The profession will have a view on this. The Department will have a view. Others will have a view. But when it comes to what the role of the taxing master is in all of this, yes, we will engage further as we're asked. But it is relatively recent, and that's possibly why the committee are in this grey area, if I may describe it, as to how this is exactly going to be firmed up. Hopefully that helps.
No, very, very helpful.
Yeah,
So you done?
Yeah.
Patsy?
Yep, thanks very much, and thank you for inviting us along here today. It's great to be in such lovely circumstances. If you could just treat me like a clean sheet, right? This is an area that I know very little about, right? So if you could talk me through the process. So reading there what could be about 1,000, 1,100 cases per annum. Now, how many staff do, if you like, the sifting, the auditing in the office for that? That's the very first thing. Of those staff, how many are qualified to do that type of auditing of costs and stuff? That'd be important too. And this is another thing that's niggling the back of my mind, so I have to get this one out. Does Mr. Moore, does every individual, we'll call it determination or adjudication, whatever you want to call it, in costs, must that be done by yourself? Reason for asking that is you're obviously a man of extensive legal practitioner, and you've been in a large legal firm. Over that period of time, you would have had numerous, I'm sure, solicitors and barristers and everything through your hands. What happens when, there's your man, sure, he and I best buddies, or he and I worked collectively on a good case there a while back. Just give me an idea of what happens there, because part of this is the emphasis is right throughout is the impartiality of your office. And as I see it, what the department's trying to do is come in, take over, and maybe through you the wee buns like England, and Wales of the 2,500 limit, and keep you at that level and hand everything over to the department itself for control. We'll not call it adjudication. For control is probably a better area of thinking, as I see it anyway. So if you could talk me through that, please, and just advise me how the process works.
I suppose we're going, there's a fair bit to unpick there in that question.
It's sure you're well up for it.
One of the interview questions when I get appointed.
All right, well,
but
okay.
In terms of will I have come into contact in my 30 years of practice with lots of the people who bills I'm assessing now? Yes. It's Northern Ireland. It's a small jurisdiction. Mm-hmm. I think you might be better asking the solicitors in the bar what their impression is of me, but what I can assure you is I am not in the slightest bit shy about taxing off costs where I think they're unreasonable, regardless of who is before me. I take the role very seriously. Mm-hmm. Before I was appointed, I was also Deputy County Court Judge. Again, in a small jurisdiction, you have to take difficult decisions. Mm-hmm. And I suppose the two things I have to apply to the approach is, fairness, trying to be fair to people. The law sets out what factors I have to take into account when I'm looking at whether it's a small bill or a big bill. The same approach is taken. And yes, there are 1,000 cases on average coming through. So there are 4 staff working with me, and I'm probably very fortunate that I have 4 really experienced staff who've been there for 20 years. I think I'm the 4th taxing master that they've all worked for. I'm fortunate in that regard because I'm come in with a team that is really familiar with the role, take their job very seriously. They're like 4 mini accountants. Mm-hmm. If you've ever dealt with an accountant, you'll know that they're prepared to ask difficult questions, and they absolutely do. So whenever the bill comes to me, it's ready to be assessed. Some, in 1,000 cases, there are bills that can be assessed maybe in 15, 20 minutes. There are other cases that are more significant because they have been through a long legal process and many hearings, and that might take me a day. I do regularly bring the lawyers in to ask them about the work that they've done. If I think that the information that they've given me is light on the extent of the work, I'm not in the slightest bit shy about demanding more information about the work and getting it broken down properly for me.
Yes, I'm getting there, but I'm getting to that point because the nub of the thing is the impartiality. I'm not in any way decrying your ability to do that, but if it came to those circumstances where, say, for example, I don't know, maybe some of your family was a solicitor and that popped up in front of you for adjudication or determination, is there a process whereby that's set aside and somebody else has to make that determination?
Yes. So right. There are certainly 8 deputy masters who could all
right, okay.
In theory, step in to tax a bill. A judge, in theory, could tax a bill. Okay. I have had 1 or 2 cases where my previous law firm have had to come before the taxing office. It's probably only 2 cases, but I certainly would not hear those cases or any involvement in those cases.
That's where.
But I think that's the same as any other judge who has a familiarity with some background in the case. They'd have to step aside.
All I'm doing here is having you clarify the impartiality of the office. Okay. Then to bring it on to the DOJ themselves, and what can you elucidate us a wee bit more as to what they have been saying to you, their motivation is around this? Because have they said anything along those grounds other than just to keep the books right?
I'm not sure really we
can't go. No, that's okay.
I'm not sure we should really comment on that.
No, all I'm asking is if they give some clarification themselves as to why this is a motivating factor. That's all. If they said it here or not, I'm not asking the policy reasons. I'm trying to get into the pragmatic aspect of this.
Well, they haven't to me now, but I don't know if there's anything we can really add.
No, that's grand. That's okay. That's okay. Thanks very much. Okay, Chair. Thank you.
I think, Patsy, with regards to any conversation we have had with the Minister, it's basically because of one of the issues being the fact that there's 7 million with regards to the uplifting fees she said that she couldn't account for, or she didn't account for at the end of the year. But of course, as the Lord Chief has said, that there had been a process here with regards to a working group for many months with regards to, and the lack of the actual increase over the years. So, Ciara?
So thank you very much for coming along, and it's really, really good, because I know I have requested a few times in the committee for yourself to be in attendance, so we can have further clarity of exactly what your current role is, the scale of the team that's currently doing it, the independence that currently exists. And I suppose we all kind of know the reason of how we've got to here through the audit or whatever, and it's about the accounting officer in the department having that level of responsibility. So for me, I am a bit confused at the minute, because it's quite difficult to make decisions on this when you don't know what the replacement is.
Yes.
But one of the areas I would like clarity from yourselves on, you had a substantial working group in relation to solicitors' fees and how that worked through its process. So how does the fees from barristers currently, is there a range, is there a vary for the likes of yourselves and 8 other taxi masters to be able to assess bills? Just, I suppose that's one question. It's just, how does it currently work regarding the fee structure for barristers? And then obviously, secondly, and you may not be able to answer that, but how can you ensure, because the profession will generally know exactly as time goes on the scale and level of work, and I have spoken to barristers and solicitors, and I know it has changed quite dramatically over the years regarding scale. How would the department be able to ensure that they're abreast of all that knowledge, like yourself would be? Because I'm a bit confused as to what the taxi master future role will be if this comes into effect. Yeah. So that's kind of 2 areas I would like maybe.
Yeah, I think on the first area, the issue of hourly rate is nothing new to solicitors. Yeah. Solicitors always work on hourly rate and time-based. It would be new for barristers, because barristers in this area work within what's called a brief fee, which is a fee to cover the work, but it doesn't break it down in the same way. So that would be a change. I say that by way of explanation of legally aided barristers, because barristers who work for, say, government departments are paid on an hourly rate. And there are rates, saying, for departmental solicitor barristers who are briefed, or Crown solicitors briefing, that are there. So there is, it's not alien, but within legal aid, the way that barristers have set fees is by way of a brief fee, which the master then looks at. And actually the master, I think, if I'm right, would actually ask the barristers to say, well, how long did you work on that? As some reassurance or an audit. So I'm not going to make a case either way, because I'm not a profession, as you can understand. The bar may have a strong view that this shouldn't change, or, to be honest, the bar might suggest, well, there's some barristers who have marked hourly rates in other areas, so we can look at that. That's open, I would have thought, to some discussion. And then there has to be a discussion about the level of it. On your second question about expertise, again, I think that's for the department. In terms of this, and keeping abreast of, what a big medical negligence case actually involves, what a big family case actually involves, what a big judicial review actually involves. All I can say is, within this judicial role, we appoint people who have been members of the profession, who have that, I would suggest, expertise inbuilt. But I'm sure the department will address you or firm that up in due course, because you can't look at costs without an understanding of the landscape of law. And I mean, the landscape of law has changed substantially, even in the 11 years we're talking about, from these fees going up. in terms of complexity, the amount of new criminal offences we have, particularly in the area of sexual offending, domestic violence, which are really welcome, but are on the books. The use of forensic evidence, the use of mobile phones, the use of expert evidence. You can't underestimate the need to have knowledge in this area to get to the point where you're paying people properly for the work they do. All of that said, there does have to be a proper check on this because it's public money, and I come back to that. That's what the taxing master has traditionally done. If there's an alternative, it'll be debated. But at the moment, we have a model here, which I would suggest looks at all of these elements in the way that we have described. But it's a very good question, your first question. The major change in all of this, if you're looking at hourly rate, would be for the bar, legally aided people, to adapt that rather than a brief fee. And they, I'm sure, would have something to say about that. Yeah. So I wouldn't say yay or nay on that. Obviously, that's a policy thing.
So just in relation to, we're on the Justice Bill now, we're talking about a clause, and I'm a bit concerned, has there been previous discussions and meetings with yourself as taxing master? And are you over, you don't need to divulge any detail, but are you over the detail of what they're proposing? Because I know they have come to committee and it says that they're working quite closely with yourself back and forward. So are we close to coming with a proposal from the department as to what they potentially are replacing the current system with?
Do you know? I mean, I'm not sure we know that, but no. We have had discussions.
I think the simple answer is no, I'm not. Right. I haven't been provided with all the detail as to what has been proposed. The first indication that there was a change in how the legislation might look as a draft came to me in early November, and maybe 2 weeks before it was coming to committee. I think it was discussed on the 20th of November. Yeah. That was the impression I had, but that's as much as I can say about that.
Yeah. No, thank you for that. But I need to highlight, I am seriously concerned that there has been a total lack of communication and engagement with yourselves on this, because this hasn't come to us in October, November time. I've been asking for this for over a year with department officials, and a few months back I've asked again, and I've been reinforced that they had been engaging with yourselves, because it's quite difficult for us to actually, as policymakers, to be able to make decisions and stuff when we're not over it. And here today, once again, we're not getting very further on.
Yeah. Well, it would be wrong of us to say, I think, that they haven't engaged with us. I think the problem lies in we haven't seen a final proposed product, as you maybe haven't. And we are open to further discussions to see that. Yeah. That's really where we are.
Yeah. And just can I do one final one? In whatever discussions you have had, what do you foresee the future role of the taxing master? Because I couldn't get any answers from the officials either at our last meeting. So,
well, it is what it is until there's a change to the Judiciary Act. And if the department propose a change, that will have to be debated, because that would be a substantial change to how we operate and look at costs in Northern Ireland.
So that puts on a very good point. So if I'm right in what this clause is saying, it removes the ability of the taxing master to deal with the civil aid piece. That really only leaves you about 20% of your work.
Take
I'm
legal
right,
aid out.
Yes.
25%, I think.
25%.
Yeah, probably roughly 20, 25.
So it's a massive. If we think what we think this is doing, then it could be a massive change.
Yeah.
Massive change. Connie?
Yeah, thank you both for meeting with us today. I just I wanted to ask, not around the specific cases, but in general, terms, how many claims come before you for legal aid that you decide are too high that you deduct down?
Do you know?
I think you really have to be very careful with the statistics on if you were getting statistics that said, like, of 1,000 bills, there's a change made in 50 or 60% of them. I'm not saying that's what the reductions are, but you could have a minor change in the majority of bills. For example, a travel cost. Like, the bill can be from the very small to the very substantial. So you could have minor changes, which I'm taxing off because someone has claimed 100 miles instead of 90 miles, and it's a very modest change. I think what's important to say is that each case is looked at case by case, and I wouldn't want to say that there is X percentage of cases that are reduced, because you could get the wrong impression.
Okay. There's a real difference between something like a travel cost and there could be something far more substantial, which is not really comparing like for like. Is it fair to say?
Yeah, I think that's fair to say.
And do you uplift more or do you decrease more that come before you in general?
Again, in answer to Mr. McGlone's question, I the test is really what's fair and reasonable. Okay. If I think costs are fair and reasonable, I'll allow them. But if I think that they're unreasonable, they'll be deducted and taxed off. That's the rule. It's on a case by case basis, and it does involve me looking at a range of factors, including the importance of the case to the client, and a lot of legal aid cases are really important to the clients. The complexity of the work, the time spent, but I'm very focused on what work was actually done on each case, and I think that's the fairest way for me to look at what should be paid by legal aid.
Okay, and I think you'd spoken as well about you have a process in which you can refer someone to their professional body.
Yeah. If
you feel it's unreasonable, what are the kind of the steps for that? I mean, I assume it's not one strike and you're out. What's kind of the process that you would go through before taking that decision to refer someone to the professional body?
I think that can come through, I should say, not just the taxi master, but legal services as well, if the claims are too high. I don't think there's a staged approach. I think if somebody does clearly mark too much in any case, that can be referred. I know the Bar Code of Conduct refers to it as a disciplinary offence if you mark too much. I assume the Solicitor's Code of Conduct is the same. That's the sharp end, but it does happen, and it's dealt with by the profession. In the absence of being able to ask you about the policy legislative change, I think that's me, Chair. Thank you.
Okay, thank you, Con. Doug?
Thank you, Chair, and thank you, Lady Chief Justice and Master Moore. Great title, I have to say. It's like a dark art. Yes, I've got to be honest. I came here thinking I had clarity. I'm leaving here with no clarity, and I don't want to drag you back to clause 28 again, but I am, because I just need to get it on the record, because I can only operate, and I'm reading across what you have written and what you have said, very insightful, and what I'm getting from the Bar in their evidence and what it says in the Blue Book. And that's where I am, and that's where I have to be. I have to start there until somebody gives me something different. So there can be no conjecture. It's what's written down. And it clearly states that Clause 28 will bring in a new Section 59A to the Judiciary Act, which will preclude the High Court and Court of Appeal from granting orders of taxation for legal aid costs, but will refer that to the Department, and the aim of the clause will be to restrict the role of the taxing master in legal aid. That's where we are now, regardless of what else is said. Can I ask, and you might not be able, but does that have a negative effect on the independence of the judiciary to be able to function if we're now handing out stuff to a department who, rightly or wrongly, will always look at where the cost is as opposed to the need in some cases?
Well, what you said, I think, hits the nail on the head in terms of the issue that can arise rightly, because it changes the structure away from the independent judiciary. And that's a question, to be honest with you, the department are going to have to really articulate an answer for you, along with this other element of, is there a revised proposal? But you're right, you simply have that as it stands is speaks for itself.
Yeah, and we can go no other than what's actually in front of us.
Yeah.
And I think, Karen outlined it very, very well, probably better than I am. Can I then just ask, it's a very simple one, if I can, even for yourself, Master Moore, what we have at present, does it work?
Yeah, well, I don't. I mean, if I can help, I don't perceive that that there's any issue with the process. I don't get complaints about the process. I think possibly the wider picture is the cost issue, which is a part of a bigger picture, which the department obviously have in their mind, and I understand that. Yeah. But in terms of the actual process, the office we have here, the way this works, I'm not sure that there's a particular principled objection raised to it. There's just an alternative, which I think, as we've realised, is driven by other matters beyond us that the department are looking at after this increase in the fees that the Master rightly and lawfully had to look at as part of his remit. But would you like to?
Yeah, the process is very similar to the process that exists in other jurisdictions.
Yeah.
It's tried and tested. I haven't come into the role looking to reinvent the wheel in relation to any aspect of the process. I will bring my own views and judgment to the exercise, but my views and judgment are that there are checks and balances there in the process. There are a number of stages before anything gets to me. And when it gets to me, I'm determined to scrutinise the cost very carefully.
And I get that. I get that sense that actually Clause 28 is trying to reinvent something that's actually working quite well by itself. But is there anything, you may not be able to answer this, sorry, Master, but is there anything where you look at what you've got now and you say, actually, this might help? The overall principle of what we have doesn't change, but this little tweak here or this, is there anything that jumps to mind? Sorry if I can, because I'm concerned that we've been asked about Clause 28. There's no alternatives to this. What I've been told is, the department has the necessary legislative and administration in place to determine payment for those services. That's the word salad. It doesn't mean anything. So I'm just wondering, is there anything or nothing jumps?
Sorry, Mr. Brady, I think that's sort of taken to me into my view on what the legislation is. I don't think I can really comment.
And that's a fair one, but I had to ask. Can I ask one very last one then, and it's for yourself as well? How are we addressing fraud and error within the legal aid system? How's it going? And I've raised this on many, many occasions, and I know we've been tackling this and things have been getting better and better, but where do we stand now in fraud and error?
In terms of my role of looking at cases on a case-by-case basis, certainly I haven't seen any issues that I would consider are fraudulent in terms of how bills and costs claims are being submitted to the taxing office. And you've got to remember that when it gets to me, High Court judges already looked at the case, and the cases that are before me are all in the High Court or Court of Appeal. So the question of fraud in those cases and entitlement to legal costs is very unlikely to be a big issue, and certainly I haven't seen it in the 18 months I've been in post as a concern. If you're referring to a wider issue of fraud in relation to someone who's claimed or applied for legal aid, well, I think that's more a matter for the Legal Services Agency, who deal with that issue of the certificate in the first place rather than me. I'm at the end point.
Yeah. I think as well, Mr. Beattie, that legal services have really got quite a sophisticated, good structure in place now to try and weed out any claims that raise a red flag that they can raise with by and large the profession, which is what they do, as far as I'm aware.
And the reason I ask that question, and it is the wider question of the legal aid budget, is because the accounts have been qualified over so many years for fraud and error, and we do know that some of that is just genuine error, and some of that word says fraud is mistakes as opposed to anything else. So I'm just trying to get a sense, how are we on top of this, and is it coming down as far as you're aware? Because certainly since I've been in the Justice Committee, I think every account has been qualified on legal aid due to fraud and error. Not huge, but it's still qualified.
I think legal aid would be the best port of call to answer that,
Fair enough.
Yeah.
Good enough. Thank you.
And I think too on that, it's the actual process, and if you like, the independence nearly of the rules and the legal aid aspect too, that actually helps to qualify it to that point, because the department do not have the complete control over that budget line, and so that goes one way. Doug's question was a very good one, but I can understand on the work, on how does it work well, because you'd be reluctant to answer that question because it's your performance nearly. But just on the scale of this, so that members are aware, the taxing master has taxed off the bill in a yearly basis 4.4 million, 6.5 million, and 5.6 million. Now, again, rough sums, that's nearly about 20% of the actual fee applied for. So that's the scale of the taxing master's role in this regard. And the issue is that the taxing master varies. He's concerned with, or she's concerned with, the legal aid budget. But the department is also concerned about the Justice Department's budget. And when you look at those figures that has been taxed off, and even when you compare that to the issue that really did annoy the Justice Minister this year with regards to the 7 million uplift with regards to the fees that had increased, proportionally they're around the same figure. So this is big stuff. This is really big stuff. And so I think we have a lot more work to do in trying to determine exactly what the department's trying to do, because we have even discussed here among ourselves on the top table whilst you were answering questions, and there's conflicting evidence coming out of the department as to what they actually are trying to achieve, what they've told the committee in the sessions, what's written on the blue pages. They don't match up. And then we've got, through into the mix, the determination of the Minister to bring forward a further amendment, which we haven't seen yet. Right. And that's what's adding to the confusion here. Brian, you wanted in for a very small...
And probably questions for the department. I don't know if you maybe don't have the wording of the bill.
I don't have it in front of me, but...
So again, as Doug has done, and as I was doing earlier, just looking at the wording here in 59A, understanding what problem this is seeking to address or solve. It basically seems to say that legal aid will not be awarded in respect of civil legal services or criminal defence services funded for the person by the department. So, is there any other way that those services can be funded by the department other than by legal aid? I'm just trying to understand what that means.
I think you need to ask the department that. I would myself have a question.
Just
along the same lines.
That seems to be what they're saying. That the court can't award the order of taxation if the legal services are already being funded by the department. So I don't understand in what other way it would be. There's nothing springs to mind as such.
Well, you wouldn't need an order for taxation if, again, I'm surmising, but if there was a scale of costs that are set out potentially in statute. I'm not sure if that's what they're driving at. I'm almost arguing here in the dark.
I appreciate that.
So I'm not sure I should say too much more.
No. All in the dark. And likewise, where it's saying it won't be paid if part of the costs will be paid. I'm not sure is that in a situation where the costs are awarded, as part of a court ruling. So someone's been given legal aid, but
Well, look, if legal aid is granted, you have to be paid.
Yes, but if the other side loses the case, and part of that might be that the awards of the defence is awarded, so the legal aid then wouldn't have to be paid from the public purse.
That's right.
Yeah.
And that can happen. That can happen too.
So, and I suppose from the point of the public purse, that's only right then.
Yeah.
Okay.
Okay, Patsy, you're wanting in, and again, I'm loath to go round the table again.
No intention
so
of it. No intention of it. Lady Chief Justice, you mentioned earlier the whole question of forensics, developing things, moving at a fast pace, and all that. I'll maybe draw you into an area of something that is moving at a fast pace that's hard to watch, and that's artificial intelligence, for example. Now, if I bring over, where's my question going? That is, if we're in a developing new age, how do you see, process-wise that is, how do you see the role, function of your office developing and improving, because everybody can improve?
How long have you got on AI? That's a whole day.
Oh, absolutely.
Could I suggest we park that to the next session, which is about delays? If that's okay, because it's about delays, and I suspect...
I can come back to that on delays.
Well, I was thinking just how AI can be utilised for those delays, because everybody has to reflect on how their businesses or how their processes are working with this fast evolving new artificial.
I'll tell you what we do. We'll bring you in first, Patsy, in the next session. That do?
Right, okay.
That do, please.
Thank you.
Okay, well, listen, thank you very much, Lord Chief and the Master Mayor. Thank you very much for that. That's been very informative, yet very confusing. But it's actually good that we are confused, because then we can go back and seek the unknowns, the unknown unknowns. If that's okay.
That's a positive spin.
That's a positive spin on stuff. But it's been very, very helpful. I suppose is what I'm trying to say in a concise way. So thank you very much. I'm not sure, Master Mayor, if you're going to stay on for the delay piece. You're quite welcome to do so.
I'll need to step
I think he's back to his duties. So.
Yeah, okay.
Thank you.
Well, thank you very much for your attendance. We really do appreciate it, and it's lovely to meet you. Thank you. Okay, agenda item number 5 then is delays in the criminal justice system. Lady Chief Justice oral evidence. Can I refer members to page 77 to 155 of the meeting pack for the relevant papers? Can I remind members that at the meeting on the 20th of November 2025, the committee agreed to request oral evidence from the Lady Chief Justice, the Police Service of Northern Ireland and the Public Prosecution Service Northern Ireland on delays in the criminal justice system. This was following the oral evidence session from the Department of Justice Permanent Secretary on Criminal Justice Inspection Northern Ireland's Transforming the Criminal Justice System in Northern Ireland report, and correspondence from the father of one of the victims of the Greenville Hotel tragedy, in which he raised concerns about his lived experience of delays in the legal cases and the lack of progress and communication in relation to correspondence in the Public Prosecution Service. Members will be aware that the Lady Chief Justice cannot discuss individual cases, and that the Greenville Hotel case remains sub judice. The intention of this session, therefore, is to focus on broader, systematic issues and causal factors in the current delays in the criminal justice system. So I hope we're all mindful of that, folks. Can I thank the Chief Justice for supporting the committee's work in agreeing to provide evidence on this important matter? And so can I invite her then to make an opening statement? Thank you.
Thank you very much, Chair. I'll try and be brief in this because of time, and I understand there will be questions in this area. I'm not going to address individual cases, as you've said, but I am conscious that delay is an issue that continues to exercise everyone who's invested in the justice system, and rightly so. It exercises me. And we do have delays in the system. I can't deny that. What's the effect of delay? Well, there are consequences for everyone, not least those who are within the criminal justice process, and the victims of crime and their families are people who just cannot understand why their cases are taking too long. I should say delay impacts upon defendants as well. Mm-hmm. And, what it can come down to is a lack of fairness potentially being argued in a case because it's gone on so long. It can increase costs, which means it's related to the other issue we were touching on. And there's a danger that it can diminish public confidence. We do have to be careful with our rhetoric in this area, generally not to heighten public concerns. And what I mean by that is I think we can recognise the issue without really leading to a position where people think that the system isn't working, because it is working. It just could be better. I have spoken about delay a lot. I remember I gave evidence before on this in March 2024. I sit on the Criminal Justice Board. I look at the statistics in relation to delay. Delay just impacts across justice, but criminal justice is a particular area that I know you'll be interested in because of the Crown Court and the high-profile cases that are dealt with at the high end of offending. But I would suggest also the cases even in the middle bracket and perhaps the lower end, because they all have a victim, they all have somebody who is being charged with an offence, they have witnesses. And the problem at the minute is that whilst I think we were in a good place last year to be dealing with the backlog that we had, I think that's gone a little bit backwards recently, and I can't avoid coming to the fact there's been a withdrawal of services, and I will do that in a moment by the bar. But what I do want to say is we know there's delay. We've known it for a long time in criminal justice. I also have picked up the issue in family justice as well, because I worried that it perhaps wasn't getting the same attention. And I have looked at that through various initiatives, and that is equally as problematic for families not getting their cases worked out. Because in my view, I've said this before, if you don't get the family justice element of cases right, you can end up in the criminal justice system. The Criminal Justice Board have a number of initiatives towards speeding up justice that I'm committed to from my perspective. But these must all be framed by a number of things. My office gave me a statistic that in comparison to March 2020, there are 62% more defendants now before the courts. Added to the sheer volume of business within the courts is something I've already touched on, which is the complexity of cases. Rightly so, we have many more bespoke domestic violence and sexual abuse offences on the books, but we also have all of this forensic and digital evidence that we have to grapple with. Delay is also system. It must be. It is system-wide. What I mean by that is it's not just something that attracts to the courts. And actually, whenever at Criminal Justice Board I raised this question, the delay in cases has been broken down to the various different stages. A lot of the statistics say delay, but a criminal case starts at complaint, through investigation, through PPS, whether they prosecute or not, and then the court. Now, I'm not saying there aren't delays at the court, but it is system-wide. And I looked at whether or not there was an overuse of adjournment in the courts, for instance. I actually sent staff from my office over to the Crown Courts, and we didn't actually detect that on a systemic basis due to the role of the judge. What we detected was the PPS weren't ready. There were issues with expert evidence, was a big issue. Probation weren't ready. I should say I'm trying to develop a form to show adjournments, so I have more empirical evidence going forward what they are related to. But what it means is, and I'm not saying anything that's not new. Again, people are stretched at all ends of the justice system. Police will say they're stretched, obviously. PPS are stretched. Probation are stretched. We can't get enough experts involved in some of these cases. And then we have the legal profession who are in a position where they're saying their remuneration for these more difficult cases needs to be looked at. It hasn't been looked at for, I think they're in the 20-year bracket as opposed to even 11 years. So that's compounding the issue, and I'm very worried about that because it compounds the delay that we have in the system that we've been trying to work with. I also should say court service do a very good job within the parameters that they work, but we don't have enough courts. We don't have enough Crown courts. I have successfully argued that we should have 15 Crown courts operating, but that was an increase from 13. But I've said if you give me 17, I can really make more of an inroad into the Crown Court cases. I need more judges to deal with Crown Court cases. If we have direct committal, there needs to be a thought process of, OK, you're taking out the Magistrates' Court, you're getting cases on quicker in the Crown Court, but do you have the infrastructure there? Whatever about... So we need more judges, need more courts. There needs to be more court staff. Mm-hmm. And I'd say if Stephen Heron was here from the PPS, he'd say I need more prosecutors. So it's system-wide. And that is a problem on family as well. I mean, the Gillen Review is well known. It talked about the need to avoid delay because the rot sets in. It's really hard to deal with issues as the stone gathers moss. And I'm also a proponent of more specialist courts. The problem-solving courts have been... I've gone to them first and observed them firsthand. They've been really good. I'd love to see a specialist domestic abuse court. Yep. I'd love to see court buildings that are properly set up for families who need solutions and people who are victims of domestic violence that are protected. So anyway, that's a bigger picture that we know about in terms of resourcing. Delay is not all of that said, not at the same level as England and Wales. I mean, their Crown Court backlog is over 79,000. They're not listing cases to 2030. I did check. Our listings at the minute are still within this year. But if we continue to have a paralysis in the Crown Courts operating, I'm worried about that being pushed back, and I'm worried about how we pick that up. And victims are rightly annoyed and making their case about this. I obviously am. My concern is to keep the courts operating and to maintain public confidence in our courts. I'm not part of the department, obviously, or the bar or the solicitors, but I've staked my claim that they need to talk and sort the dispute out sooner rather than later. So I'm happy to take any questions at this point because I realise this is an area that is important to you, and you may have some questions for me on. Thank you.
Lord Chief. Can I ask, first of all, you said about needing 17. Well, how many Crown Courts do we have presently?
15 can operate, yeah.
And if you say you'd one additional, then that would...
I said two.
Or two additional.
Yeah. I'm not saying anything, by the way, I haven't said to court service. Yeah. And they have tried, but I think this may come down to resourcing and staffing, as you can understand. So I do understand the problems, and the budget for this is a difficulty too. Mm-hmm. But I can only go on what I'm asked to do, which is to try and deal with backlog and get through delay. And I'm saying to really, really deal with that. And we have dealt with it very well because Crown Court judges have worked over and above, I think, what they needed to be expected to do because they're conscientious. But if we're really serious, we need to improve that superstructure, okay. I think.
How do you see your role in trying to speed up this? And how can you use your influence in that regard?
Yeah.
What's your varies around this, I suppose?
Sorry, I didn't catch.
What's your powers?
What's
around,
my powers? Yeah.
What's your powers around trying to?
Yeah. Well, we have a practice direction. So we have a practice direction 2 of 19, which is very, very detailed about what the obligations are on defence and prosecution. Cases shouldn't be adjourned. Cases need to proceed. I actually tried to slimline that into a one-page laminated document so that people actually read it and got the message. So that's one thing. Second thing is training. We have a benefit here with a small jurisdiction that I can bring together all the judges, and I do this. I do mandatory training now for the Crown Court. We had our last session just before Christmas, and I bring them all together and I say, look, this is what needs to happen. But we can have a conversation about where the tweaks are. It's not wholly within our control. I can also engage with the other actors. So I do engage with probation because they come to me and say, actually, the judges are putting too great a demand on us because they're saying you have to have that report and we can't do it. And rather than wield a big stick and lose all of the cases and all of the probation reports, what I try and do is come up with, OK, we'll allow you the 6 weeks if you can get them done within 6 weeks, and we review that. Where I have a difficulty, actually, is experts. They are taking a long period of time to work in cases. We don't have enough. But the practice direction deals with that to some extent and really says judges need to actively case manage this. So that's where I go with training. I engage with the profession as well. And I should say, the profession are... in both the criminal and family areas, they're specialists. They know the territory. They obviously come from their own perspective, but they are receptive whenever I say, look, things have to tighten up. We've had a few training sessions where I've brought the bar as well, and that's been good because I've said there's been a bit of slippage with the practice direction. In family law, I've issued a few different practice directions recently, which have really worked, I think, particularly as to how courts should deal with domestic violence, because I worried that there was perhaps an approach that might not have been as consistent for whatever reason across. I got letters from people about this, to be honest, and I also looked at it myself. And I really put this out to say, this is how you need to deal with those cases. So I do have a role, and I hope I'm known, I think, for utilising that quite robustly. But I can't solve all of the issues on the ground, which are, I think, coming in because of the pressures on the system and other variables beyond, what I've talked about.
Okay, thank you. Patsy, your question.
Yep, thanks very much.
Artificial intelligence.
Well, that was right. Well, we're not going to take all day out about the AI, but what I'm trying to get at, Lady Chief Justice, here is you mentioned a number of areas, like, say, for example, the police, the PPS, probation. If you were to do, and many of those are out with your own control, but if you were to go right through all of those and itemise things for ourselves, because we're the ones that are supposed to be looking at policies, and are there any particular policies that need, or practices for that matter, that need changed, updated, whatever it might be? And if you could elucidate, just give us a wee bit of an inclination as to what those are, according to your own extensive experience.
Look, as you can imagine, we are training on AI in England and Wales. The Judiciary have issued a practice direction on it. It needs updated because AI moves so quickly. But the bottom line on that is AI is not, in my view, a replacement for some of the systems that we have, but it's a complement as long as it works in a transparent way. So you have to be transparent that you're using AI and that there are internal checks. Now, some of the areas that we're talking about, criminal justice and family justice, there's a lot of sensitive information there. So you have to be very careful that you're not compromising privacy and sensitivity. However, I think myself we need to really adapt, and we are working on this, and I know the police are in particular, on things like what I mentioned there. Phone triage seems to take forever. We need to be proportionate in our search of. It's not me, but the investigators need to be proportionate in their search of, well, what are we trying to get off this phone that's going to help this criminal case? I think you could utilise AI there. Video, CCTV, you can streamline and use it to help. It's a fact of life anyway. People think it's new, but we're all subject to AI through our mobile telephones, for instance, that choose things for us. So it can help, and it should help. It's not going to replace the way that we work within the system, but I think we can streamline it. As long as I had a confidence in the operating systems, that I wasn't going to lead the justice system into these sorts of integrity issues. I think it's a good compliment, actually. Disclosure, if I sort of sidetrack slightly to give you an example, disclosure generally in areas can be thousands and thousands of pages. And the human doing that's going to take an awful lot of time. The computer doing it's going to take less. If it's a proper product, my only worry is, do you spend more time checking that it's a proper product and lose the benefit of it? But I don't think so. I think it's very easy to be a sceptic on AI, because we just naturally are, and the law doesn't particularly like these radical changes, but I'm a proponent of being up to date on the tech as long as it is validated and using it to our benefit. Yeah.
So that takes me naturally just on to the use of experts.
Yep.
Because I'm sure someone somewhere, and I don't know who the particular experts would be that you're referring to, but probably someone somewhere is developing at this very moment artificial intelligence which could not supersede the role of, but complement the role of those experts, and perhaps facilitate or speed up the ability of the whatever evidence that they're going to give, present before yourselves in court. So can you give me an idea, please, as to what type of experts that you're referring to there,
right.
Their availability and the likes?
There's a spectrum. The main issue with availability is in the area of psychiatric, and that'll come in criminal trials a lot. It comes in family as well, psychology and family. You can also, that's one area, the opinion expert. Then you've got the forensic expert. I actually think AI is probably used in radiology, for instance. I could be wrong, but I think you'll find AI has got quite a good billing in the medical world. And then you have this new group of expertise in the modern landscape to look at, for instance, CCTV evidence or other evidence. Of course, you've got engineering as well. So, yeah, it's a very good question. We need to be smart about this, but to use the tech in a way that gets us through delay. I imagine these other areas of expertise are using AI, particularly some, not so much, I would have some query on the opinion expert. I mentioned that opinion category at the start. Save that medical notes and records are a massive amount of documentation, so they may be able, a proper model might be able to fine-tune that into what you want and avoid a delay on that.
Yes. Well, we could talk forever about this because it is such a fascinating day, but thank you so much for that. Thanks, Chair.
Doug, maybe?
Yeah, thank you. Chair, maybe Chief Justice, I do get concerned a little bit about the speeding up justice and where we're getting to and where we're in problem solving. And I think you're right that things were moving in the right direction. Then we've hit the present impasse between the bar and the department, and I'm really concerned that there's a standoff here that one isn't willing to give, and that's my real concern. And I think you highlighted it very well, that the people who are paying the biggest price is the victims here, and I think that there must be a focus on that. But when I was looking at the speeding up justice, and it talks about the remit of the magistrates' court, and I'm just wondering, is there anything that's moving at any speed or can move at speed, at pace, even to deal with the present short-term problem, but the wider problem of delays, to increase the remit of the Magistrates' Court in regards to sentencing? Or indeed, I met with Stephen Heron about 3 weeks, maybe a month or so ago, and he talked about, in this present impasse, that some of the cases that need to be held in the Crown Court, which can't, being held in the Magistrates' Court, but sentencing being bound over to the Crown Court when it becomes available, that sort of thing. I'm just wondering, is any of these feasible, or am I just...
No, they are feasible.
They're not?
No, they are.
Oh, sorry.
I have nailed my colours to the mast consistently before the Criminal Justice Board, and I think publicly, to say I think the Magistrates' Court sentencing powers should go up. In most cases, apart from criminal damage and maybe some other outliers, you're at 12 months. I've said magistrates need better sentencing powers to get through, particularly the raft of new legislation we have that's come about because of really good work about trying to end violence against women and girls. So I've said all that, and I think, to be honest with you, there is a will to do that. It's with the department. They haven't really said that is not, in principle, something that can be worked through as long as it can be resourced, because they'll have to look at the other outworkings of that. I am a bit worried about direct committal, as I mentioned earlier. I do think that, we've had this debate for a long time. We no longer have oral evidence, but we still have committal. It's holding up cases in the Magistrates' Court that are the more serious cases. Get them straight into the Crown Court. Properly resource the Crown Court to do that, but we will get on with criminal trials a lot easier. There is no point in having a committal and putting the victim potentially through the trauma of that preliminary when you can get straight into the Crown Court. But Magistrates' Court should go up in terms of sentencing powers, in my view. I mean, we are talking about the Crown Court in terms of delay. That gets the attention. But the majority of our criminal business is actually in the Magistrates' Court. Now, the other end of this as well, and it is a piece of work that's coming from Criminal Justice Board, from the policy partners, not me, but the policy partners, is some out-of-court disposals for other areas. Take some work out, free up the Magistrates' Court to deal with the more serious offences, give the magistrates greater sentencing powers, have direct committal. And in my view, I actually don't think there is much pushback from anybody on all of that. But I appreciate the department have to work out the logistics of all of this. And I can assure you they are doing that. And these things do take some planning, because the worst possible option is if you do something and it comes off the rails because you don't have the infrastructure. You have to set up rules, you have to set up, your whole structure to adapt to it. But absolutely, I think you're right on that is a way forward for us here.
And I suppose I think you were very direct there, and I think that's really important, very direct. And here's my concern when I talk about the speed of speeding up justice.
Yeah.
I'm literally looking at this slide that I've been looking at for a year.
Yeah.
But what you're saying is, look, it does take time. Let's scrutinise this, but it could be a real game changer, actually, if we increase that sentence remit. And
yes,
and it just seems to be slow to get movement in regards to that. Would the sentencing bill, do you think, be a vehicle to be able to? Does it take legislation to do this?
Yes, it will.
Primary legislation.
I assume so. Yes.
Yeah.
I assume so.
So we could be looking at, and I'm just sort of speaking, and you can nod or say no, whatever. But we could be using the sentencing bill to be able to do exactly that.
Well, yes, but the sentencing bill, I think, is where it is. There's quite a lot in that, and there's a limit in this mandate. I'm told, in terms of what can be brought forward. I mean, I have my. You'll know I have my other area that I've been promoting, which is the filming of sentencing remarks, which is put off to I'm told, the next mandate. So that is the difficulty.
And I know this is more about the Public Prosecution Service, but they're going through the whole and extending the no prosecution files, which are coming out from the police now. So the police are dealing with this, which means there's no file going to the public prosecutor. Does that have an effect on yourselves, or does it not have?
Not really. I don't think.
No.
I mean, I think it'll show at some stage in the system in a positive way, I would hope, because it gets out that middle adjudicator. But I haven't seen it as yet.
Yeah.
I'd like to see it. And if it does, get to a point where there is a frustration with judiciary sometimes that every file is treated in the same way, and that's not to take away from the fact that the landscape is crime, but there has to be a proportionality to look at some files that could be fast-tracked, for want of a better phrase.
Yeah.
Because I have people in the bail court, sometimes in the High Court, who say, and I often say, well, are you not going to plead and get on with this case? And they say, the barrister says, there's no file. But it's clear as day this person wants to get their case progressed.
Yeah.
So, a bit of work there, a joined-up piece of work between police and PPS, I think could be very beneficial. I think that, to be fair to both, they're alive to this.
Oh, they are. Yeah.
I suppose, the flip side of that is, and I understand this too, they don't want to miss something or to have, a problem that arises in the one case that they do fast-track that's wrongly fast-tracked. I get that. But there are risks in everything. I would rather see a system that, as the project puts it, speeds up.
Thank you, Jim.
Okay, I'm just thinking there, I smiled to myself when you talked about the limited time in the mandate, and there's two bills coming, Justice Bill and Sentencing Bill, and you'll never know what MLAs will be thinking about with regards to amendments.
I know.
It can scare you.
Yeah.
Brian?
Okay, thank you, Chair. I welcome, Lady Justice, what you said about the out-of-court
Yes.
settlements and or disposals, and the desire to increase the use of that. I welcome that. You've spoken quite plainly to us, and that's appreciated. There is a public perception that equivalent cases in Northern Ireland take longer than elsewhere in GB. Do you think that is the case in general terms?
Can I be honest with you? I've heard this now a number of times, and I get a bit frustrated. Not with you, obviously, but because it's a valid question, because it's out there. Don't hold it against me. I think that what happens is all of the criminal cases are lumped in together, and that evaluative assessment is made. I would say that in England and Wales, what does tend to happen is that the very serious high-profile cases do probably go a bit quicker. But I think if you broke down the statistics, the bulk of cases that are in the category just below are not proceeding any quicker than our cases, and that's in areas of, serious sexual offences and such like. So I think it's a bit of a misleading picture, to be honest. And I did go and sit by invitation with some of the judges in the Old Bailey, and I saw how they have quite a good system there with a cohort of judges to fast track a category of gangland murder cases, for instance, and they have a system to do that, and that's a showcase for something that's really good. I was really impressed with it, actually, but there's a bigger picture than that London court, which is well set up for it, because you go out into the county courts or the country courts, and I don't think it's as positive, and I don't think the cases are proceeding any quicker than ours in the other levels. So that's my view on it, and that's not to say that some of our cases are trundling, but I think, as I've tried to say to you, I do keep a very sharp eye on this myself as best I can.
Okay. And no, thank you for that assessment. And you mentioned earlier about, well, again, it would be a common perception about an overuse of adjournments of cases. And so the question is, notwithstanding what you've just said, is there, and you said you speak to judges about this, so is there a challenge to that, to the overuse of adjournment? And is there a need at times for tighter timescales? Justice must be done fairly, but if either the prosecution or defence is repeatedly coming back and saying, oh, we're not quite ready, I mean, do there need to be tighter timescales and things will have to proceed the next opportunity?
And that's called case management.
Yeah.
And you might detect that I'm quite a stickler on case management. I do set timeframes, and I think it's very important. And I've tried to invest that culture with the judges, but to be fair to them, I'm not on the front line of the Crown Court and the pressures in there. And to be fair to them, it'd be wrong in some cases for them to push on a case and then have, an appeal to the Court of Appeal and me say then it wasn't a fair trial. Mm-hmm. So I do understand their position, but I have, I think, at least started the conversation and kept it going, that you can't adjourn unnecessarily. Mm-hmm. But I'm not satisfied they were. When I looked at just even a very small snapshot, it was largely due to prosecution not being ready, defence being a bit late at the table on what they wanted to raise, and that's a pressure of work thing. Expert reports, So, the way to deal with it is to continue to make this point that there are time scales and you have to keep to them. And I mean, if you're in the Court of Appeal, if you're breaching them, you have to apply for an extension. So at least I have a handle on it. Mm-hmm. But it is difficult. It's difficult for me to be overly critical of the Crown Court judges. I keep coming back to, because I don't know the nature of the cases or the challenges they have, and the issues that are sort of between the lines. That, for instance, there are not enough prosecutors, or there's evidence that just did arise the day before. That is very important. And okay, question is, why did it arise the day before? But it's a criminal trial and it's very important. And if we don't run fair trials, we're just going to run up appeals, which I don't want either. So that's as best I can do, I think, in that area.
Okay, thank you, Chair.
Emma?
Thanks, Chair. Just very quickly, in terms of the Crown Courts, whose responsibility is that for? Is that DOJ for the funding piece around that?
Yes, it's within the department, and that's through court service, who then operate the courts.
And you have already requested that?
I have.
Okay. And what response have you got?
Well, you have to make a business case in relation to this, so I continually have to vouch for why I'm asking for this. I say the stats speak for themselves. I say, I need more of this, judges in particular. I've actually commissioned a piece of work from Queen's on that to get an evidence base on how many more judges I need. And then court service say, OK, we'll consider the principle of that. But they have an obligation to also say, but we have funding pressures. And that's beyond me. I go on need. I think the justice system has to adapt to the needs that are obvious through the crime stats that we have. Crime has actually gone down, I think you'll find, in some of the crime stats, but the complexity of the cases, the family cases that we have, in a way, I suppose, naively, I think it's self-evident why I would need more courts and better courts. But there is a funding piece there, and I've gone over this before as to how justice has really been at the bottom end in terms of getting an increment for money.
Okay, and just one, I suppose, not really a follow-up, but another question. We had a small conversation there around the current impasse, and I know that a lot of how it's been presented in the media, I've been uncomfortable with how some of it has been framed, in that an entire profession are being sometimes labelled as, you know, entitled, or that this is a very wealthy section of society, and the evidence tells us that that's not the case, and that we have young people entering this field of work who are not by any means earning a lot, and particularly the working class and minority communities who are entering that field, and we want to see more of those people, and we want to see more access to justice for those within society who are on the outskirts. I have a concern that perhaps those people are being pitted against victims of crime and families of victims of crime, and that there's almost a little bit of emotional manipulation going on, particularly through the media. Is that something you would comment on, or something that you would have a view on?
I'm not sure it's really for me to comment on that. As I've said, my concern is for the people who are affected by this, understanding that the profession have a perspective, the department have a perspective. I'm not sure that the issue isn't one that can't be spoken about in whatever forum that is going to solve it. That's not going to be the media forum. What I think that's going to be is, knocking heads together on what should happen here to get through this sooner rather than later. And I think I've made my position quite clear on that. I did write to the Minister and the Bar in the same terms in November. I said I predicted that there could be a problem, and I asked both of them to get to a table to sort it out. And I still hope that can happen. I think there are, to be fair to both sides, ongoing discussions about this. But it is, as every week goes on, it's going to have a ripple effect on the people who are, who are invested in their cases. But it's also going to store up more costs down the line, and it's going to really put the dampeners on my delay initiatives, because that's going to be another burden I'm going to have to face.
Okay, Connie.
Yeah, thank you. Something I picked up on what you'd said around direction you'd issued to family courts.
Yes.
And I just wondered if you could go into a bit more detail. And I do think you'd mentioned you'd got some letters about it, and I think a few of them were probably from me. So
they may well have been.
Something I would be particularly interested in.
Yeah, I think there was a general theme from these letters that this is in private law, so private law is breakdown of a relationship, children in the middle, that domestic violence wasn't being looked at seriously enough, and also there was a perception that the residential parent, usually the mother in these advances to me, were being forced into giving contact whenever there was a domestic violence issue. So I've tried to streamline this into asking courts to work out at an early stage what the issue is and deal with it. I set up a bespoke group of family judges, included Judge Gillan, back from retirement, to help me to advance all of this. And it was supposed to be for 6 months, but I've kept it going. And we met last week. And funny enough, one of the issues that came up last week was the need for the profession to properly indicate on the application forms that there is domestic violence, so that the judge can work. That might sound simple, but that the judge can then timetable it properly at the start of the court proceedings and make a finding if the judge needs to, or not make a finding. I tried to bust the myth that there's a presumption of contact in Northern Ireland, because there's not in our Children Order. There is in the Children Act. So the Children Act is in largely identical terms, but there's going to be law to take it out. Actually, in England and Wales, we don't have it here, but it's right to say that the rights of a child usually involve having a relationship with both parents. So the guidance just sets out things that people should know, but I think it will help streamline cases for those people who are in a critical area because they're bewildered as to what's happening. There's a perception they're being forced into contact, and there's a perception that they're not being heard, which I want to reassure them that, again, I train family judges on this, and that there are very many really specialist family judges, particularly at the Magistrates' Court, who know the territory. I should say one other initiative that I'm thinking about from the group last week is I don't really understand why there shouldn't be a one-stop shop with family law. In other words, you know, the domestic criminal side of things, the family side of things, the money side of things. And I'm not saying anything that Judge Gillen didn't say in his review. So I am looking at that. But I think the domestic violence guidance makes the point that this now has to be specifically addressed and at the earliest stage, and that contact is not automatic. It depends on the circumstances and the risk to children. Every case is different, of course, and you know there's different perspectives. You can't be overly prescriptive, but at least I think what I've done is set out a template that's workable and it's public and everybody can see it, which I hope will help. I also have piloted a family resolution court it's going to start next month in the care centre, which is the intermediate level at the county court. And I'd like that to go to the Magistrates' Court to effectively offer judge-led mediation at the very start to see if we could avoid, you know, delay and acrimony in these cases that, in my view, doesn't help them.
Thank you. I think that's really useful. I'd love to have a whole committee session on family courts, Chair, but I know we are extremely busy. And I think something that you mentioned on the presumption of contact, I mean, after it was announced the law was changing in England and Wales, I had people contacting me to ask how can we do this in Northern Ireland. And when I explained to them we don't even have this in Northern Ireland, and they were quite surprised. And I won't go into individual cases, but even organisations like Women's Aid have said it's almost a culture.
I know that.
Do you recognise that? And you know, is that really what you're trying to do with?
I do recognise that. I do recognise that. But that's what I'm trying to do. I'm trying to educate in terms of what the right steps are to get to the right result, which ultimately is in the best interests of a child and deals with risk, because there's risk analysis in all of this and you have to balance the risks.
No, that's helpful. Thank you so much.
Kieran?
Thank you. Just on the family courts, I would be really appreciative, because you're well aware as a committee we are currently have a raised paper and we're hoping to be presented quite shortly on this very issue.
Yes.
We have met with you in the past, particularly in relation to it, and I do think it's a cultural thing as well, regardless of us not having it. There's just too many individuals that have came to very many MLAs and have felt the same. So the ongoing work you says, is it published? I would be really keen. Could we get
the guidance document?
The practice?
Yes, I'll get it sent to you.
I think it'd be really useful.
It's on Judiciary and I website, but I'll get a copy sent to you.
It would be excellent to have that, and likewise on the Family Resolution Centre, the pilot, to get more information on that.
Yes, I have a template document I can send to you as well on that.
Oh, that would be great. Thank you. So, just there's 3 other areas I wanted just to look at. So, I might mention there's 3 and give you an opportunity then. So, the first one, and it's something that I have raised in particular, but I know other members have raised on a continuous basis, and it is our concerns about the high remand rates.
Yes.
And the impact that's having on our prisons and the overcrowding. And we've seen the reports, the Public Accounts report in 2024, that we were sitting at 37% of our total prison population on remand, compared to 18% in England and Wales and 28% in Scotland. So it's just your views on that, and what can be done there. Secondly, obviously, in particular, live links, obviously with this Justice Bill, and I acknowledge and appreciate the work that you have done regarding the physical, remote and hybrid attendance in court, and you updated that back in October. Just could you share just your views in relation to the key benefits and potential risks do you feel associated with the increased use of live links? And in particular, I know for myself, very much so with regards to vulnerable adults and children, and ensuring that they're fully aware of the use of live links, consent for live links, all that.
Yeah.
That's an area of concern that I would have, but I would love your opinion on it. And then thirdly, and it's just general, it is systematic wide regarding delays in justice. But I feel just from various conversations that I've had with various organisations, it's nearly because it's so systematic, one can blame the other, which is naturally enough because they're in that bubble of the work that they need to do and they're waiting on one another. And even being in court and spending 10 minutes in court, adjourn. Within 10 minutes, there was about 10 people went through the courts, and it was quite shocking to me. But a lot of it had to do with, as you says, lack of investigations. That's one. Now, this is just from a 10-minute.
Yep.
Lack of investigation by the PSNI to be able to assist to deal with cases in courts, and I know that's probably a resource issue. Now, that's just my perception. The PPS, total lack of resources as well, and the length of delays, because I would be liaising with them myself on one particular case at this moment in time. And then you mentioned, obviously, experts. So just your feeling on if there was one key area regarding that could really speed up, because it is systematic, and I know from the courts and the work that you've done, but across the system, because you're at the final tail end of this. But as you say, there's other things that need to happen prior to it comes to court.
Okay.
Is there something there regarding resources, or which area do you think could have the biggest impact? And just finally, if I could just...
That's three now.
No, it's just back to family courts.
Okay.
And you're well aware that the key issues that we raised through what was happening in the family courts, likewise, those individuals are also looking at the Department of Health and what can be done there. And in particular regarding the quality of evidence, because we're speeding up evidence, but how do we ensure the quality of evidence is checked into the fore? And this I am in relation to particularly social workers and family court. I don't know if you can comment, but it's in the area. Just I have a concern. I would like to seek further information on. So sorry, but
okay, I'll try my best. That's 4, but I'll go through. High remand rates, big issue. I've visited all the prisons on that. I think there needs to be a greater appreciation when the courts have a look at people who come into them, that they may be eligible for bail. I think there is this sort of knee-jerk reaction that in serious cases there should be no bail. Bail is pre-trial. It doesn't mean that you're not going to be convicted or imprisoned for a long period of time, but we have obligations to look at whether the risks can be met by the imposition of conditions. And there needs to be a public appreciation of that. I think some cases you don't get, they're not suitable, but some are. And why I think this is problematic is, do you know what the worst thing is for a victim? Is, I believe, and I've heard this, that somebody who is convicted and say gets 2 years is immediately released on the day because they have served it on remand time. That is not vindication. We need a better appreciation of the fact that we can manage risks on bail. Look, there will be outliers where it doesn't work, but again, I'm back to there needs to be a better system-wide approach to that. The other issue with high remand is you don't get any reparative work whilst you're on remand. So it's a no-brainer, actually. The stats are good, I would say, with youth, as opposed to male adult. And with women, there is definitely an opportunity through bail programmes to help there and not have women remanded. And Hydebank are doing good work on that. There's a companion piece, though. These people need places to go and live. The judge is not going to bail them if they don't have a proper address that we can be satisfied they're not going to reoffend from. So there's a tie-up with housing. which is very strong, and health as well. And you mentioned health rightly, because you can't put somebody out who's going to, have a psychiatric episode and re-offend. We couldn't do that. So I agree with you on high remand rates. We need to think about that. But, we are in that space. We do understand that. You don't want a position that England and Wales have had with prison numbers leading to people being released early. I mean, that if ever there's a shock to public confidence, it's that, in my view. So we do have the balance right, but I think the public need to understand what bail is about, to really, look at us calibrating this issue in a better way. Live links, I'm a fan of live links. I think it's really good. I think it streamlines the system. It actually saves costs. So professional people within reason don't have to come to court. They can link. We did do this for experts for years, but now we're doing it with more frequency and for lawyers as well. Downside, some people break the rules. It's very rare now. You're not to obviously be disrespectful to the court through the link. We don't get too much of that. You're not to record. I don't think we get too much of that. I think it's worked really well, and why wouldn't we do it? So I'm really pleased about that. Is there one thing that could help with delays? Yes, I would point to disclosure. In criminal cases in particular, disclosure comes at the last minute and is it's too voluminous. It's not proportionate. But I have one of my Crown Court judges working on this specifically, and he is, if he hasn't already, preparing a draft practice direction on that for me, which I will roll out with judges. And I think what I'll do with that is bring the profession in. I can't say that's going to be an immediate fix, the work he's doing, because there is a cultural element to this. Unfortunately, disclosure's left to the last minute. Now, by disclosure, I mean, your records, police evidence. It is left to the last minute. The fault lies across the board on this. But if we can crack disclosure in criminal law, I think our cases will progress a lot quicker. And your last question was about a join-up, health, really important. Problem-solving courts are good, but they need a buy-in from health to look at. I would say over 90% of our cases probably have addiction issues somewhere along the line, mental health issues, problems with housing, education. We really should think about joining up in a better way. We do it ad hoc, but I would like specialist domestic abuse courts. I'd like a rollout of more substance abuse courts throughout the province and other problem-solving courts. But the departments need to work together on that, in my view.
And just on that with the courts, because obviously the mental health didn't proceed.
No.
It was to proceed.
Yeah.
So is there a working group set up regarding the specialised courts?
There is, I think.
And was there? And when's the last time they met? And is it something that...
Yeah, I think there is within the department. They tend to be pilots.
Yeah.
And I worry about that a little bit, because you can go on with pilots forever and a day, but then it doesn't have the strength of being permanent. I think there's a funding issue with this. But my worry is that it goes to the bottom of the pile because of all of the other pressures, whereas I see this as something that can, by way of early intervention, militate against increased crime or increased family dispute. So I'm a big fan of it.
Okay. No, it's good to hear. Thank you.
Aoife?
Thank you. I'm new, so I didn't think I would be actually asking anything of you, but it's really refreshing to hear your take on the family courts and the work that you've done around domestic violence. And I know that we've tipped on it before, so I don't want to repeat any of the questions, but you spoke in terms of delays in the court system and reference work undertaken in relation to domestic violence and family courts, including the importance of the of experts and needing more of them. And I couldn't agree with you more. I know just in different examples, we hear time and time again that with the lack of experts that are in these cases, that social workers and CCOs are actually having to become the experts in their own right with the reports that they come with. And so could you elaborate a wee bit on how specialist expertise would help address delays in domestic violence cases and family courts, and whether that approach could be expanded more widely to improve timeliness and outcome for the courts and outcomes for the victims?
Yeah. The social workers in our jurisdiction are obviously under pressure, and I worry about them having, after a day at the interface trying to sort out things, have to go home and write up a big long report.
Yeah.
So where I am on that is I would prefer that social workers, who are important, who do have an expertise, give us in bullet point form what the headlines are, so that we can at least, as judges, isolate the issues and see, do we need something else? So do we need another expert? You mentioned CCOs. They are amazing. We don't have enough of them. We should have one in every court, because what they do is they allow for people who come to court to have somebody who knows the territory helping them resolve at an early stage. So the family resolution pilot looks at that I've talked about in the care centre, that I'll send you the information on, looks at that. There is an overarching issue in family law. Domestic violence needs to be obviously determined in a particular case. That can lead to, I think, a problem with mediation, for instance, because there's an inequality of bargaining power, and I worry about coercive control seeping into mediation. But at the end of the day, in some cases, we do actually need to empower parents to make the decisions rather than the judge about issues like pick-up and timing of contact, and I'm very keen on that, but they need a bit of help. Having worked in this area when I was in practice, I really do value the social workers that we have, but I think there's a problem with trust-keeping social workers, and we need more CCOs. Do we need other expertise in a case in family? It depends. I mean, when I sat as the family judge here, you had to convince me you needed an expert, you needed a psychologist, you needed whatever it might be, because that was going to cause delay and cost. And, in some cases you did, but in some cases you didn't.
Okay. Thank you. And just one more, you just have touched on, coercive control within the family courts, and there's definitely examples where the family court is certainly used as a form of coercive control, financial abuse, and all of the above. And I'm wondering, I don't know, but, I think there's not enough recognition.
Yeah.
And I know you mentioned earlier about the criminal courts, and if the family courts, if there's any delays there, that it ends up in a criminal court. And for me, I think that there's a huge barrier between family courts and criminal courts, and we're not recognising within the family courts, or certainly choose to oversee criminal activity that's taken, whether that be domestic violence or whether that be using the courts as a form of coercive control. And I'm just interested in your take on that. Do you think that we should have more recognition, or certainly if crime is being committed, that we take that into the family courts, that we take it from the family courts to the criminal court and recognise it exactly for what it is?
Yeah, I do. Yeah, and that's what I'm saying. We have made great strides in the last number of years. And I have to say, credit to the Minister, she has been at the forefront of this as well, in terms of putting on the statute book actual domestic abuse offences. And I think that is filtering through. People understand that. Where I think coercive control actually comes in is people making repeat applications, possibly with the benefit of legal aid against somebody who doesn't. And I know that happens, but there are ways and means of dealing with that. When I was at the bar, there was a proposal, this is years ago, could be 20 years ago, to cap the number of applications you can make. or to put off people who are just using an application as a method of control. But that's where specialist judges come in, because I think you'd have the antenna to work out what's going on. The problem is you're in this area of people are entitled to have a fair trial. However, in family law, there is a provision in the Children Order, Article 179, that allows a court to restrict further applications without leave, which courts should use more often, I think, probably, to avoid these repeat applications, because that's a stress in itself, having another application.
If we bring it full circle, actually, it would help with the delays. But so like if they were not allowed to do repeat applications for the purpose of taking this person back to court, then actually it would. You would imagine that. Well,
there is a provision. There's a statutory provision 17914 of the Children Order. So a judge can impose that in the right circumstance. There's criteria, but in the right circumstance.
Yeah, and just very finally, in staying on the same topic, look, there is very good legislation in terms for people who are victims of domestic violence and being able to get legal aid and whatnot, but it's not been implemented within the courts, and I wonder why that is the case. So while the legislation exists, I think the return that solicitors or barristers get for it, or solicitors, I think, is not enough. But maybe that's for a different day. But it's just...
I actually don't know the answer to that, and I would be disappointed if it wasn't a situation where, number one, people have access to good solicitors who can get them legal aid, and then they're properly remunerated to deal with those cases. So,
thank you.
Okay, thank you, Doug. You're wanting in for a wee small.
Yes, sorry, Lady Chief Justice. It's a very pointed one, but a small one, because it's going back to the remand piece. And I just, because I'm dealing with somebody at the minute about this very issue, and we're not going to talk about individual cases, but how do we deal, or whose responsibility is to trigger? If we have somebody who's a foreign national and they get placed on remand and then they go before the court and the court gives them a disposal of 1 year, but he's already served it on remand, so he's released from court. But because he's been given a year, he should in effect be returned to his country of origin. He should be deported, which is the rules. But there's nobody there to do that. Who should be the trigger in this? I know it's the Home Office. But who should be the trigger for them to know to be there, to be able to do that? I mean, clearly it can't be the judge. Is it the prison service? Do you understand?
I do. Probably. I can tell you, without naming a case, I had a case where this very issue arose, but for some reason, unbeknownst to me, the Home Office were there, which was brilliant, so that I could say, all right, what's actually happening? And they said this person was on a flight that evening or whatever. I think it's probably the prison who would be equipped with the information to flag that to the Home Office. And, if there's not a protocol about working together on that, there should be. It wouldn't take too much.
No.
Yeah, but you wouldn't want a gap in the information on that, because that's going to lead to a real anxiety among, I would have thought, the victims in certain cases,
Well, and I'm dealing with one exactly now. So exactly as you've just described it, it seems that somebody wasn't the trigger to tell the Home Office to be there. And it seemed everybody was looking different directions on it.
If there is a practice, I'll let the committee know a direction. But my own experience was there was somebody there in the case I had, and there should be an information share, and I think it should be through. It would have to be through the prison, to the Home Office.
Oh, perfect. Thank you.
Okay, thank you very much, Lord Chief. Thank you very much for your time here today. It's been very informative. You've been very helpful to this committee in both sessions. So, again, thank you very much. We're truly indebted to you for your.
Well, thank you very much. As I say, I do value our interaction. If there's anything I can do to help on an ongoing basis by way of information, please let me know. You're also welcome to visit the courts. I think some of you have taken up court visits. I know some of you have mentioned it through my office. You're very welcome to do that. I'll also send in some of the documents I referred to. And once again, it really is a delight to see you here in in the RCJ. So
Thank you.
Thank you.
Thank you very much.
Thank you.
Thank you.
Okay, committee, I am going to have to fly too, so I'm going to hand over to my able deputy chairperson, who's not too pleased, by the way. But we have redacted some of the notes. So thank you very much, members. Thank you.
We get myself a company.
I'm just next day because I'm chairman, but whenever I come in, I think I hate these bits. Right, can listen to her on then.
So we're moving on to item number 6.
Sorry, Emma.
Okay, if people are content to move on, so we've got agenda item 6, which are written papers responses relating to the justice bills. You'll find these at pages 157 to 164 of your meeting pack. I want to remind members that the joint paper had raised a number of concerns by the organisations about the new Level 1 accreditation and the accreditation framework more broadly, as well as in relation to a number of other matters on community resolution notices and the Department's view of NIA and CRJI as accredited sources of local expertise and experience for restorative justice. Are people content to note the Department's response on these, or do people feel that they need more information? All right, Ciara?
I would be content to note at this stage, but I'd like to get feedback from CRJ and alternatives, because it seems to be loads of misunderstandings, but I'd be keen just to hear how they felt the meeting went, if that's okay.
That we do that?
Content.
Yeah, everybody. And then there's, at 6.2, we've got more correspondence from Professor Keegan of Queen's University Belfast. If you go to pages 165 to 168 of your meeting pack, you'll see a paper from Professor Brown providing further clarification on the repeal of vagrancy amendments following the Department's response to his draft amendment and oral evidence on the proposed repeal legislation. Are members content to note the update from Professor Brown, or if any further information or comments are required? Go ahead, Brian.
No, I just want to welcome his reply. I think it's well written, and he's gone into detail there. First of all, in England, Wales and the Republic of Ireland, when repealing the vagrancy legislation as is proposed here, it says they retained modernised offence being found on premises with intent to commit offence where there is repeated intrusion, intimidation and targeting behaviour, which might fall short of burglary. He also responds to the Department's saying that the provision, that his proposed provision of begging causing harassment, obstruction of public order concerns might be incompatible with Article 6 of the ECHR, and he states legal cases for that.
Is there further information that you want us to?
No, I do want to comment, because I think he's given a very considered reply, and also the creation of the offence of organising, controlling and facilitating begging by others. So it's certainly it's a reply that I'll want to be drawing on myself.
So you put on the record on that,
Yeah.
That's no problem. And members, in line with the committee's previous agreement, unrestricted papers from the Justice Bill will be published on the committee's webpage.
I did just put a note on it. I think we need to share. I think obviously we can't avoid what has been said through the vagrancy and what he's brought forward again. And I think we need to share with us with the Department of Justice and
So
seek
are
further
members
response.
content to forward that on?
Yeah, certainly.
Because we need to be 100% satisfied
So then
with the departments.
the next item then is item number 7. And we have a statutory rule of police pensions amendment regulations 2025. The examiner of statutory rules has been waiting patiently. So are members content that we move into closed session to take a briefing from Angela?
Yeah.
That's the nod. Members, can I refer you then to pages 54 to 65 of the meeting pack for the relevant papers. And can I remind you that at a meeting on the 20th of November, which I don't think I was present for, the committee agreed that it was content with the Department's proposal to make an SR to amend the Police Pensions Regulations 2015. The rule is subject to the negative resolution procedure and will come into operation on the 1st of February 2026. As we've just heard, the examiner's formal report on the rule will be available on Friday. However, the examiner has indicated that other matters have been resolved to her satisfaction. The rule will only be drawn to the special attention of the Assembly in relation to drafting errors, and the examiner is content with the Department's proposals to correct these errors. If everyone is content, following that advice from the examiner, are we okay to go ahead with the proposal for the statutory rule?
Yeah.
What page are we at?
54 to 65.
In the table pack?
No, in your meeting pack. The table pack dealt with the errors that are the issues, I suppose, that she had flagged.
Okay.
Have you found it, Brian?
No, but that's fine.
Well, I have to formally put the question
Okay.
that the Committee for Justice has considered.
Right.
Sorry, did I give the wrong number?
We get the wrong
I think it's 169.
Yeah,
Aye.
sorry.
Yeah,
Sorry.
the wrong number here. Brown arm. So that the Committee for Justice
Right.
has considered SR 2025-190, the Police Pensions Amendment Regulations 2025, and has no objection to the rule.
Agreed.
Everybody says
Agreed.
happy?
Yeah.
Yep. So I can seek members' agreement to table the following motion seeking to... Oh, sorry. That's wrong. Yeah.
Move on.
No thanks. It's just a minute. Yeah. So agenda item 8 then. The Crime and Policing Bill, second legislative consent memorandum, consideration of committee report. Members, these are at pages 8 to 101 of the table pack. At last week's meeting, the committee noted that a second legislative consent memorandum for the Crime and Policing Bill had been laid in the Assembly on the 13th of January. Although the standing orders referring legislative consent memorandums for committee scrutiny and reporting do not apply because this is the second LCM for the bill, members agreed at last week's meeting that the committee team should prepare a draft report for consideration at today's meeting. The committee may wish to consider if it has an agreed position on the second LCM. And can I seek members' views on whether they're content with the proposals to extend the provisions outlined in the draft LCM for the Crime and Policing Bill at page 93 in the table pack? Mm-hmm. Everyone's happy? Yep. Mm-hmm. Any typographical or formatting errors in the report will be amended at proofing stage before it is circulated to all MLAs and published on the committee webpage. Have members any proposed amendments to the draft report? No. Happy days. So I'm going to go through it now in each section. Are members content that the title page, contents page and powers of membership page stand part of the report?
Content, yeah.
Agreed. Background section of the report, paragraphs 1 to 4. Are members content that the background section of paragraphs 1 to 4 stand part of the report? Agreed. Are members content that the provisions which require legislative consent section of paragraph 5 stand part of the report?
Content, yeah.
Can I refer you to paragraphs 6 to 19 of the report? Are members content that paragraphs 6 to 19 stand part of the report? Yeah. And then conclusion at paragraph 20 to 21 of the report. Are members content that the conclusion section at paragraph 20 to 21 stands part of the report? Appendices, refer members to pages 21 and 22 of the table pack, which lists the items for inclusion in appendices 1 to 3 of the report. Are members content that the appendices stand part of the report?
Yeah, content, yeah.
Can I seek members' agreement for the minutes of today's meeting to be added to Appendix 2 and agreed?
Agreed.
Can I seek members' agreement for the report to be published on the committee's webpage and issued to all MLAs?
Agreed.
And can I inform members that the debate in the LCM is expected to take part on the 2nd of February and you will reflect the committee's consideration of the LCM in that debate? Okay, perfect. Item number 9, pre-legislative scrutiny, Department of Justice correspondence. Can I refer members to pages 182 to 199 of the meeting pack? And I remind members that at its meeting on the 27th of November, the committee heard oral evidence from departmental officials on the forthcoming sentencing bill, and officials agreed to provide follow-up information on a number of issues. Can I inform members that the department has now provided a written paper responding to each of these requested areas? And can I ask members if you're all content to note the department's response or if there's any further information or clarification required? Doug?
Chair, it's a very simple one, and that is, when are we going to see this sentencing bill? Because we were at October. We did ask the question before Christmas. It didn't happen. And now I'm reading here that it will be introduced in January 2026. Well, that's next Monday or Tuesday. It's the only time it comes in. Then it's not in January. It's going to be pushing into February. So is it worthwhile just... I get everything it says in about how complicated it is. I have no issue with that. But I think it's only fair that we get a deadline where this is going to come in. And I don't think it's down on the order papers for next week. So it's not coming in January at all. So this is not accurate.
I would 100% agree. I would have concerns too. It seems to be running along and time can...
So as a committee, we'll write then asking for that information. Everybody's agreed on that?
Yeah.
Yeah, brilliant. Then we've got item number 10. Can I refer members to pages 200 to 203 of the meeting pack for the relevant papers? The Department has provided a written paper on the review of sentencing policy. We'll be aware that the Justice Minister provided the Assembly with a written ministerial statement on the 14th of January announcing the review, and the Department's paper provides members with a summary of the review's proposed format and content. The Department has indicated that it will engage with the Committee throughout the review process. Are members content to note the paper, or do you need any further information or clarification? Ciara?
I'd like some clarification because I just got a response today to basically say consultation will be next year. So yes, so I would like to know what resources has been put into this, because it is very, very important pieces of work. And I did meet last week with the head of that's carrying the sentencing review. Particularly, there's a few areas there, and I know there's important work that needs to be done. But I'd like to know what resources have been put into it. What's the team that's involved in it, and why it'll take a year? And can has any been prioritised, or just I would like the finer detail of how we go about this. I know you don't want to be rushed, but I had assumed, in my ignorance, that come the summertime it'll be going out for public consultation. But now I'm being told it'll be in 2027.
Okay, so is everyone happy that we write to asking those points of clarity? Perfect, we can action that. Agenda item 11, proposed increase to the general civil jurisdiction of the County Court, Department of Justice written paper. Members, can I refer you to pages 204 to 111 of the meeting pack for the relevant papers. The committee has received a paper from the Department advising the committee of the Department's intention to increase the general civil jurisdiction of the County Courts. This relates to the financial boundaries that determine whether civil claims, such as for personal injury, clinical negligence, breach of contract or defamation, are heard in the County Courts or the High Court. Paper outlines some of the background and rationale for the Justice Minister's intention to increase in this general civil jurisdiction from 30,000 to 60,000, which will include claims for clinical negligence, increase the district judge's jurisdiction from 10,000 to 20,000, and increase the upper limit for defamation cases in the county courts from 3,000 to 10,000. The paper also advises that the Department has consulted with the LCJ, and she has welcomed the changes to the general civil jurisdiction. Department aims to have all necessary legislation and consultation in place so that the changes can be implemented in autumn 2026. Members, are you content to note the paper?
Mm-hmm. Yeah. Just one area I think it would be useful that we're kept updated regarding the LCJ's office and their consultation process.
Okay, we can ask for that.
How that is going and the outcome of it.
Okay, we can ask for that, or if everyone else is happy. Agenda item 12. Can I refer members to pages 213 to 219 of the meeting pack? Members of the committee has provided a written update. Oh, sorry, that didn't make sense. The Department has provided a written update on the long-term cross-executive strategy to reduce offending and reoffending, with the intention of scheduling this for executive consideration in 2027, as well as a shorter-term strategic framework for 2026-2027 that will provide a bridge to the new strategy by aligning existing executive initiatives and exploring new collaborative approaches to reduce offending and reoffending across the North. Members, are you content to note the paper, or do you require any further information?
Okay.
Happy days. And then we've got the correspondence item. You'll find your correspondence at 222 to 313 of the meeting pack. I'm going to draw your attention to 6 of the items, 4 of which relate to the same issue of the handling of legal complaints. Members, you will then have an opportunity to comment or ask for further clarification on any item of correspondence that you have a particular interest in. So 13.3, 13.4, 13.5 and 13.6. At the 4th of December, the committee considered correspondence from an individual in relation to the handling of legal complaints and agreed to write to the Department of Justice, the Department of Finance, the Legal Services Oversight Commissioner and the Law Society for their response to the particular questions raised in the correspondence. Can I inform you that the Department, the Law Society and the Department of Finance have issued their responses to the committee at items 3.3, 13.3, 13.4 and 13.5 respectively. The response from the Legal Services Oversight Commission is still outstanding. At page 240 of the meeting pack, 13.6, members will also find further correspondence and copied correspondence to the Legal Services Oversight Commissioner from an individual in relation to their complaint made to the Law Society and in which the individual wishes to bring the committee's attention to what they describe as systemic issues affecting the ability of members of the public to pursue complaints of alleged professional misconduct in a clear, transparent and accountable manner. Members, can I seek your views on how you wish to go forward with these issues? Can I suggest that we might forward those responses to the individual in question? Is everyone happy with that?
Yeah.
Happy days. 13.11 and 13.12, I'm going to take these two items together. Can I refer you all to page 264 to 277 of the meeting pack, which contains correspondence from Peter Martin, MLA, about pro bono assistance for self-litigants. The correspondence contains a letter from a constituent of Mr Martin to the Justice Minister outlining his case as well as answers to some Assembly questions that Mr Martin has asked in relation to the matter. Can I refer you to page 278 of the meeting pack, which contains correspondence from an individual in relation to the justification for restricting jury trials. While this is not relevant here, the correspondence also makes reference to issues faced by litigants in person. Can I advise you that in early 2024 the committee requested the Department's view on research by Professor McKeever on litigants in person. In response, the Department advised that there is more to do and that the research would help inform policy decisions and interventions along with other relevant review findings, though process would be subject to the current difficult financial environment and other priorities. Can I get your agreement to forward the items of correspondence to the Department for comment on the general issues raised and to request an update on any work in respect of litigants in person?
Great.
Agreed. Can I also get your agreement to respond to Mr Martin's constituent to advise that the committee is unable to intervene in, investigate or adjudicate on individual cases and to outline the action that the committee has agreed to take?
Great.
Agreed. Can I seek your views on how we wish to go forward? Yeah, that's satisfied. Are members content to note the other items of correspondence in the pack?
Yeah.
Perfect. The last then thing is our forward work programme. You'll find the latest draft of the committee's forward work programme at pages 315 to 323 of the meeting pack. And can I remind you that we will receive advice in closed session from the Bill Clerk on the Justice Bill and begin informal deliberations on the provisions of the bill and the planned amendments. Can I remind you also that the Minister is scheduled to attend the meeting on the 5th of February. Can I ask you to inform the Clerk if there are any particular topics that you wish to raise with the Minister? It's useful to provide those in advance, but members will of course be able to raise other issues on the day. Are members content to note the forward work programme? The next item is Chairperson's business, and there is none this week. Agenda item 16, any other business? Anybody have anything else they want to raise? Happy to tell you that the date, time and place of the next meeting is Thursday the 29th of January 2026 at 2 p.m. in room 30 Parliament Buildings. Can I adjourn the meeting?